Hello friends, let us start our chapter from civics of class 8th, that is understanding our criminal system. We have our own criminal system. As we know that in judiciary we take civil law, and there are two types of cases comes in the judiciary: the civil cases and the criminal cases. Civil cases are those cases which are related to relatives problem like property, etc. And criminal cases are those cases where we see some crime happened. So these cases are taken by the criminal court. Now, what is the proper criminal judicial system of India? If someone violating the laws go or done action against the constitution of India, that comes in criminal activity. And if someone do this thing, then obviously we have to inform police, and then we have to file FIR. Now as we know that after this what would happen? Police arrested the person to whom he think is a criminal. But is the police who decides whether a person is guilty or not? No, it is not the police who decides all these things. There are four key players in the criminal justice system of our country, India, and these four are the police, public prosecutor, defense lawyer, and judge. Actually, there are three: the police who investigate it, public prosecutor, we can say the defense lawyer. They both are the lawyer who presents their own views in front of the court, and later on, the third one is the judge or the judiciary who decides whether a person is guilty or not. So, this is how we go according to that. Let's first clear our first question, which raises in our mind: what is the role of the police in investigation getting a crime? Now, when a police get a complaint, then obviously it file a FIR on it and then start its work. Now, what is a FIR? FIR is the first information report which police registered when any person complain of it. Then there is a green register where police write the complaint and all information: time, date, the person who is complaining, the person about whom it is complaining, etc. Either police write it or a person, or the person who complained write it, and this is how the signature of that person is taken. That thing is known as the first information report or the FIR, and on the basis of this FIR police starts its work. The work of the police is first its work is to investigate the complaint. The complaint which received by the police has to be investigated by it, and this is how police can use its resources for investigation. Now, what is investigation? Actually, it includes It includes the recording statements of the witnesses. It goes and contact with the witnesses, take their statements, record those statements, or write those statements. Police also try to collect different kinds of evidences from an opinion. The opinion which police make from the statements of the witnesses and the evidences which police get, it make its own opinion on it, and this is how it file a charge sheet on in the court. What is a charge sheet? Charge sheet is a report of complaint in which the whole complaints or is written the, and this is how the police charge a person that this person is a criminal person or a person done a crime, and that is why police arrest that person. Because of these reasons the charges are these all charges which police put on that person according to the constitution of India. Means it mentions the article also under which article police arrest that person or make cases against that person. The police investigation is always have to be conducted in accordance with the law mentioned in our constitutions, and it police also respect the human rights and doesn't do anything wrong which hurt humanity. The police are not allowed to do any wrong thing during the investigations, like to torture or to beat or to shoot anyone during their investigations. Its work is only to do investigation according to the framework of our constitution. Now for that our constitutions mention all these things, or we can say the rights are given to the citizen, and it guaranteed that police cannot do anything wrong with it, and that is comes under article 22. So this is how Article 22 of our Constitution guarantees to every arrested person with these following fundamental rights, and these rights are: first is the right to be informed at the time of the arrest. It is the duty of the police to inform that person that why police is arresting that person, and it shows to the person the permission which police get from the magistrate, means the warrant, arrest warrant. Means in other word, or we can say the person can ask to the police that show the arrest warrant and also tell him why police is arresting him. The right to be informed be done, and the second one is the right to be present before a magistrate within the 24 hour of arrest. Means when police arrest a person, that person must be shown to the magistrate within 24 hours. For example, like if police arrest a person in the evening of on the evening of Friday, and the court is off on Saturday also and on Sunday also. If the court is off, then police go to the magistrate home and present the arrested person in front of magistrate in magistrate home, and then the magistrate gives his or her decisions whether to give bail to the person arrested person, or as what the police is saying, send him to the police custody. But that person must be shown to in front of magistrate within 24 hours of arrest. The right not to be ill-treated or tortured during the custody of police. Police can just ask that person and try to take the statement of that person, which can help the police in its investigation. And that is why police take permission from the magistrate for its custody. But during its custody, police cannot do anything wrong, means to ill treat with that person or to torture that person. Police is not allowed for all these inhuman activities. And if police done these types of activity and tried to take statement from that person, even then there is no value of that statement. As our next point is, the confession made in police custody by the accused person cannot be used as evidence by the police, because it may be possible that police force that person or ill-treat and torture that person, and that is why the person gives the statement. So there is no value of that statement, and police cannot use that statement or confession made by the accused person in front of the court. So this is how we have to understand that the police custody is just for the help of the police in its investigation, so that police can investigate properly, and the person who is in its custody help police for its investigation. Under article this 22, the other things which comes is like the boy under 15 and the woman cannot be called to the police stations only for the questioning. Means if police wants to ask some questions in which the children comes and the lady comes, then it is the police who itself go to the home of the children and the woman and then ask questions to them, which can help in their investigations. But police cannot call them in the police station. This is how we see the article 22 gives guarantee, such type of guarantee to the arrested person. And not only this, like there are many other guarantees in which, like if police arrest a lady person, then there should be a lady police with them. And if the lady is under police lockup during the night time, then in the police station there should be a lady police constable. So this is how our constitution gives so much right to the person who is arrested. But why these rights were given to this person? The reason is that that person is not a criminal, that person is a accused. Means it may be possible that person is a criminal, or it may be possible that person will become or is innocent. So for judiciary, for constitutions, that person, they both treated with this person as like an innocent person till it is not decided that the person is criminal or not. So in this first part we done till here. We continue our next part. Till that, any kind of problem you can send your comment to me, or you can visit to my blog vipindogra.blogspot.in. And that's all in the first part. Thank you.